Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again, and we are back with a new video on your legal affairs for your CLAT and AILET and other law entrances for your 2022 and 2023. Before we move ahead, I do this basic request to all of you to hit on the like, share and subscribe button, and also hit on the bell icon for these regular updates. If you have any queries or you are looking for a counseling or you're not able to understand how to go about the exams or what to choose exactly, you can definitely give us a call on 5x9 75392 and we will be happy to help you all. Coming to the next part, if you are not a part of our Telegram channel, do make sure that you are subscribing to our Telegram channel for all the articles, news updates, and also from expert advice from the mentors too. Now coming to the first news for the day. So the Delhi High Court has given a ruling on door-to-door ration delivery system. So the Delhi High Court recently scrapped a proposed scheme of the Delhi High Court, the Delhi Cabinet. The scheme was to supply the rations to the doorstep of the beneficiaries through government empowered direct to home delivery agencies. Now, who's opposed the scheme and why? So in 2018, the Delhi Cabinet approved a scheme called Mukhyamantri Ghar Ghar Ration Yojana, in which the scheme was opposed by Delhi Lieutenant Governor, and he said that the scheme may not achieve the stated objectives of the elimination of corruption, as it only replaces old service providers with the new ones. Okay. Now, he also said that the Delhi government should take approval from the central government since the National Food Security Act is enacted by the parliament. And also the Delhi cabinet decided to go ahead and notify the scheme in February of 2021, but the center objected to the name of the scheme. Due to this, the Delhi cabinet dropped Mukhyamantri from the name of the scheme and decided to go ahead. Right now, here, what did the Delhi High Court say? So the Delhi High Court Ration Dealer Union moved to the Delhi High Court, challenging the scheme, arguing that the scheme bypasses existing fair price shop owners. The center also supported the petition and held that the scheme is in contravention of the NFSA, that is National Food Security Act. Now, the Delhi High Court also held that the Delhi government can offer delivery of food grains, okay, at the store step. But with its own resources only. And also the court also held that the Delhi Lieutenant Governor should refer the matter to the President for decision, and as there is a difference of opinion with the Lieutenant Governor, right? So it can go to the President for consideration also. Now coming to the next part is that the Perivalan case is for regarding Article 142 of the Constitution of India. What was this case? Now, exercising the powers that are conferred under Article 142 of the Constitution, the Supreme Court ordered to the release of AG Perivalan, that is the former PM Rajiv Gandhi assassination case convict. Now, what are the factors that were considered by the Supreme Court while giving the release order? The convict's prolonged period in jail, his satisfactory conduct, his educational qualifications acquired during his jail time, his medical conditions, and pending recommendations of the state cabinet made to the governor in 2018 made them go ahead by taking this order for release. Now, what is Article 142 is often termed as judicial activism, provides special powers to the Supreme Court to do complete justice when law are unable to provide any solutions. Now, there are two parts and two clauses of this. According to Article 142(1), the Supreme Court can pass any order for doing complete justice in any pending case before it. Such orders will be enforceable throughout India as prescribed by any law made by Parliament or order of the President of India. And also, according to Article 142(2), the Supreme Court has powers to make any order to secure the attendance of any person and also the production of any documents or punishment of the contempt of itself. Now, the case went further. In other cases, Article 142 was used by the Supreme Court in 2016. They imposed a ban on sale of alcohol within 500 meters of the outer edge of the highway using powers under 142. Supreme Court cancelled the allocation of the coal blocks using powers under 142. They also did the compensation to the Bhopal gas tragedy victims through the Article 142. So you can see that Supreme Court has used this power multiple times. Now, the Article 142 originally was numbered as 118. It was introduced in the Constituent Assembly on the May of 27th, 1949 for discussion, but it was adopted on the same day without any debate because there was a consensus that to ensure the independence of the judiciary, the Supreme Court should be empowered with the powers to do complete justice. ठीक है जी? तो ये जुडिशरी की इंडिपेंडेंस के लिए ये आर्टिकल बहुत ज्यादा इंपॉर्टेंट रहा है. Now, Andhra bauxite mining dispute was also, there was a claim that was filed by Ras Al Khaimah Investment Authority, that is Rakia, against the Indian government for USD 273 worth of damages that were to be paid by Andhra Pradesh government to be dismissed by the International Dispute Resolution Center for Arbitration and Mediation. And there was a case that was filed by Rakia as the state government of Andhra Pradesh had failed to supply bauxite for Jarreza deposit located in Visakhapatnam district as per the agreement that was signed between them on October of 2008, right? So this was the Andhra bauxite mining dispute in brief for you so that you know what has happened there. Now the Madras High Court has confirmed to keeping politicians, businessmen away from the sports bodies. So if you know that the Madras High Court has said that no politicians and others should be the office bearers of the sports associations and federations, and upheld a single judge order in this connection. The bench of Justice M.N. Bhandari and Justice D. Bharat Chakravarti upheld the single judge order while dismissing a writ petition from the Tamil Nadu Olympic Association. Now, the Prime Minister has also inaugurated the Joint Conference of Chief Ministers and High Court Chief Justices. So the Prime Minister did this last month and inaugurated a session of Conference of Chief Ministers of High Courts, Chief Justices and Chief Ministers of different states at the Vigyan Bhavan in New Delhi. The conference was attended by Chief Justice of India N.V. Ramanna and Law Minister Kiran Rijiju. So this is a very, very important thing, that is European Union new internet rules. So there were the European Union finalized a new legislation that will require the world's big tech companies to remove harmful content, right? So the Digital Services Act has aimed towards ensuring consequences for websites and platforms that will be hosting and ban content ranging from disinformation to hate speech and images of sexual abuse. Now the legislation was being worked upon since 2020. And also, the EU parliamentarians and officials finally reached on the agreement at 23rd April 2022 in Brussels. Now, the allegations that are against the world tech giants are that they have been doing and they have been constantly failing to police their platforms, like how a terrorist attack in New Zealand was live streamed on Facebook in 2019, caused a global outrage. The internet's dark side also includes e-commerce platforms that are filled with defective and counterfeit products. Also, the tech giants haven't really worked to get rid of racism from their platforms, which has been very, very prevalent. Now, what are the obligations that these platforms have? Under the new regulations, the tech giants will be required to remove the illegal content swiftly from their platforms as soon as they made aware of it. Now, the social networking platforms will also have to suspend who have been frequently breaching the law, and also the e-commerce website will be forced to verify the supplier's identity before listing their products on their platforms. Now, there are additional requirements on the larger platforms. While many of the DSA's requirements apply to all businesses, it imposes additional requirements for those having more than 45 million active users in European Union region. This list also includes tech giants like Apple, Google, Amazon, Facebook, Twitter, Microsoft, etc. These companies will be required to be under the regulations to assess the risks that are associated by using their services, and also remove all the illegal content that is existing on their websites, right? So these are the legal affairs for the week, guys. Thanks for joining this live session. Do take care of yourself. I will see you on next Wednesday with a new video, and we'll be refreshing some of our content. So need this 1 week break to create new content for you guys. So we'll be joining you back on next Wednesday with a new video on some updates about CLAT that you should definitely know and you should keep in mind while appearing for the exam. So do make sure that you come for that video. It's going to be a very, very interesting video. Some of the information that you don't know and you will come to know after you write your CLAT examinations, we are telling that to you right now. So stay connected with us. Do hit on the like, share and subscribe button, and have a nice day ahead. Thank you guys, and take care of yourself.